My name's Tom King, and I'm the founder of Toolkit.law. And as we're here on a continuing legal education session, we're joined by attorney Reid Keutzer. Reid, it's great to have you back. We're here to talk about immigration. And for those 80 plus countries with English-based legal systems, we're going to cover client and witness preparation. I'm going to go ahead and share my screen now, and I'm going to move the help sheet over. And here we go. So when we look at this, we've divided it looks like you and Ann, your partner, divided it into 4 topics: communicating the facts, understanding the objectives, understanding the evidence, and overcoming whatever your burden of proof is in whichever country you're in, whatever jurisdiction you're working under. When we look, let's go ahead and work through the green column. I'm going to make it a bit bigger so people can see it. Let's start on the green column. What do you want to walk us through?
What my qualifications are, first, because I'll tell you, I've been a practicing attorney for 11 years now, licensed here in the state of Texas, but I practice in the federal courts for immigration here in the United States. So telling a clear story, for example, is something that is a must in any court setting anywhere around the world. And some attorneys might differ in how they want to do it. My preference is always, whenever possible, I like chronological, right? I like to, when I'm preparing a case and preparing a client, to me, a clear story is chronological, but that's how my brain thinks, right? Some people might say,
Linear thinking, right? The simplest.
right,
For me, I'm the same way.
right. But some people might say, well, I want to put my strongest points forward first, and they're not necessarily chronological. So be it. But to me, to tell a comprehensive story that a judge or a jury or whoever it is that is going to be your fact finder can follow, it makes more sense chronological to me. And as far as clarity, right? Um, it's the classic what we may have learned in elementary school when we're doing a book report. It's the who, what, when, where, why. We want to make sure that we are always laser focused on telling it with some brevity, right? We don't want to go off on tangents. We want to be very clear. This is what happened, why it happened, when it happened, who was there. The fact finder can withdraw whatever inferences they want from that. It's not your duty to force them to draw the inferences that you want, right? You just need to tell the story in a very clear way.
So when you talk to your clients and you're preparing witnesses, obviously they need to know to give direct responses, correct?
Absolutely. So in the American court system, at least, we are there's a difference between what we call direct examination and then cross-examination, and there are different rules around them. And so in a lot of ways, you're going to get your quote unquote softball questions from me, because I'm your attorney and I'm there to help you tell your story within the confines of the rules of the court. And you will notice a lot of times the opposing attorney, whether that's representative from the government or whoever they may be, they will ask you questions that are very narrowly tailored, narrowly focused, forcing you to say a very clear yes, no, not letting you actually tell a story. And in a lot of ways, the courts and judges kind of have to force you a lot of times as the client to, okay, you don't get to say yes, but, or no, but. And so I have to coach the clients to understand that when it's the other side asking you a question, you don't get to expound on your answer. You have to give a direct response. It is on me to then help you clarify that response or expound on that response.
Especially since we're talking about immigration, often we're talking about the use of interpreters, are we not?
Absolutely, absolutely. And this is in any court, but especially in immigration. Most of my clients will be English second language, and it is more effective for them to tell their story in their preferred language. But when it comes to witness preparation, what you need to do is really make them understand that in a lot of ways it's double the time for a trial that we're not all communicating in the same language. And I have to tell them, look, even if you do understand what I asked you in English, if we ask for an interpreter, you need to wait. I ask it, he interprets it, then you answer, and then he interprets your answer. So it's double the amount of talking, and they have to understand just kind of that sequence of it. It's you don't want to interrupt, right? Because a lot of these things are recorded, and you are interfering with the ability for a clear record of what's being said to be recorded in your case. So you got to wait. You got to be patient if you've got an interpreter.
I loved what you put in this next box, helping witnesses understand when they're going to say something that's going to really trigger a response from the other side. That's going to be legally significant, right?
Right. So in a lot of ways, we are, as attorneys, we are we teach our clients the law in a lot of ways. Obviously, I can't walk them through everything I've ever learned and take them through law school, but a good lawyer will teach their client what is the burden of proof here? What is the law looking for specifically? What is it that what are the elements that we need to prove? Because if they know that, then they know that the way that they answer their question needs to be on those points and addressing those points. They need to understand what the goal is. You don't just get up there and just tell your story, in a narrative format. It's a Q&A, and we are trying to prove points A, B, C, and D. And so if they know the strategy behind it, it can help a lot.
Let's talk about traumatic events and staying honest.
So, right, in a lot of, let's say, asylum cases, refugee clients that we have, a lot of times it's them and their family that may be testifying. So you're having to prepare multiple witnesses. It'll be on us to kind of decide who should tell this part of the story, right? Even though if they're family, right, they're all knowledgeable about it. But who is the best person that's going to really deliver this? And in a lot of ways, if the story really hits home for them or it's hard for them to tell, people get choked up, they tear up, when they're having to recall these events. And that can be compelling for a court, right? In a lot of ways, the fact finder, whether it be a judge, jury, or whoever it is in whatever court you're in, humans kind of have an ability to tell who's being honest, and look for cues, and they can tell when things are forced. But if the emotion's real, absolutely use it, because that is a compelling point in a lot of people's stories.
We have about 2 minutes left to finish the last four cells on the left. Obviously, you don't want to exaggerate. You want to be honest, even under pressure.
Absolutely. Absolutely. And then, yes, legal jargon, that's on us to argue with the other attorney, and in front of the judge. That's not for our clients to know. And it sounds rehearsed. It sounds scripted. We want authentic testimony in every way imaginable. And so, as far as emotional outbursts, right, if you are getting frustrated, or the other side or the attorney for the government is questioning your authenticity, it's on me to prep the client in preparation. That is their job. They're just doing their job. They're going to poke holes in your story. It comes back, we have to coach them to the idea that, look, it will come back to me, and I get to ask more questions after, and I can, quote unquote, clean up your testimony, right? So they will point out inconsistencies, and then it is on me to make it consistent. You don't get to just do that by getting frustrated in the middle of court.
And
Um,
lastly, role playing.
so again, like I was saying with the, you don't want it scripted. I don't tell them what to say. Again, I like to, I do have them come in prior to, and I walk them through the process. Here are the goals and the elements that we need to prove. Here are the ways that your story fits into those elements. But I don't tell them necessarily, I want you to answer this like this with these exact words. It is their story. It's their opportunity to tell their story. And that's what a good lawyer does is they ask the questions in such a way to where it allows them to tell their story the way that they want to, but within the rules of and confines of the court, right?
Okay, we're on client and witness preparation regarding immigration cases. We're now moving to the right column, understanding the objectives of client witness preparation. What are the objectives?
The objectives are always getting a court to grant the relief that you are requesting, right? And so in a lot of ways, like we've already touched on, that is kind of teaching our client the elements of what it is that they are looking for. Because when they make their finding, for example, it is very much almost robotic in a lot of way. They will say client demonstrated this, client demonstrated this, client. They are elements that we need to show. So yeah, in a lot of ways, it's they need to understand what it is that they're asking, why they're asking it, and what the court's looking for.
Okay, obviously there are going to be legal and personal goals. We know their goal might be to join their spouse, right?
Right. So in a lot of ways, we lawyers' jobs are to kind of we take the client as they are, right? So say for example, I'll give you, if they didn't file for asylum within 1 year, but they came to me after that, right? A lot of times what we are dealing with is next best alternatives, for example. And so really coaching them, here is what I recommend as far as what we do, given your situation, given your circumstances, what's going to be best for you and your family.
I understand I like where you talk about understanding the role of both the witness and the decision maker. Can you elaborate?
Yeah, so in a lot of ways, like I touched on earlier, different witnesses, different members of the family, might deliver the parts of the story in a more impactful way. Whether that means they are more privy and to the knowledge of what happened then, they were there, because you don't want secondhand testimony or hearsay or anything like that. So but a lot of times it's also the sequence matters, right? Who are we calling first? Do we want to have your wife go first? Do we want to have the husband go first? So it really comes down to strategy, but it's not so much in a legal strategy. It's just what's the best way to tell this story.
We talked before about the importance of a timeline, especially if your judge or your decision maker is a linear thinker, but certainly as an attorney, you need to know what the timeline is.
Absolutely. I mean, we live and die by our calendar, but in a lot of ways, this is the client's case, and you know they are responsible for it as well, right? I am their shepherd. I guide them through the process. I make sure that nothing unfair is happening to them, but at the same time, they need to know about these deadlines. They need to understand, right? For example, you need to provide me with documentation that I don't have access to by this date or well in advance of this date so that I can prepare it in a format that's court acceptable, right? So they have to be very privy to to the deadlines too. And in a lot of ways, that's part of the guiding and shepherding that we do for them through the case.
I've never been involved in an immigration case myself, and I'm calling you instead of me handling it. I promise you that. But what are the typical types of delays and setbacks, at least in American immigration, that we should prepare clients for, or if you're aware of some for other countries as well.
Is here in the United States courts, and they are called the EOIR courts. And so these are people that are in, for example, removal proceedings. Historically, they took much longer than you might anticipate, right? Because I also practice in Texas courts, and you'll get your trial in 1 year, 2 years. Sometimes people are waiting for 5, 6, 7, a
That's
long
crazy.
time for their relief. And so a lot of times it's about kind of tempering client expectations in a lot of ways. Now things are changing with the new administration as far as what I've seen in the past couple months as far as expediting certain things. But for the most part, yes, I mean we are a lot of times asking for relief through, for example, USCIS, and the EOIR court is waiting on that. And we're not in control of some of these deadlines, but we just have to report to the court and say, this is what we're waiting on. This is what we had, how long we expect it to take. And typically they've been somewhat understanding.
Obviously, we need to help them understand what's the best success we can possibly reach for them, regardless of their desires, right?
Absolutely. So again, that goes back to what do we think is the most likely outcome, right? So we lawyers live in a world of, there's best case scenario, but then there's a lot of times next best alternative, right? And so preparing a client for what all the possible outcomes are, what I've seen in my experience of what is the likelihood of those outcomes. Yeah, I mean, they've got to know kind of that's what they're coming to you as a lawyer for, right? They're what have you seen? What have you been able to obtain for previous clients? What are my reasonable expectations?
Finally, the appeals process and future steps.
Well, we talk about the appellate process in advance of even the first trial that we do, right? Because, and this is kind of a unique thing in immigration here in the United States, but we don't consider the immigration courts to be Article 3 courts. They are administrative courts. However, if and when you want to appeal the decision of one of these courts, then you are in the appeals courts that are Article 3 courts. And they have a different, level of scrutiny, just like any other, tiers of courts relative to each other. But we talk to them about, if the likelihood of you getting this relief is low, here's what we can do after the fact. Sometimes it's really not to reverse the decision. It may just be kind of to further delay. And it's really up to them whether or not that is something that they want to pursue. They may have reasons for it. But yeah, it's all about giving the client as much knowledge as possible and letting them make as informed a decision as possible.
Let's go to the back side of your helpful help sheet. We're talking about immigration, client and witness preparation. Now, obviously, you need evidence. You need evidence. What type of evidence do we need to have? What do we need to understand about what type of evidence we're curating?
We've requested, right? So, for example, police, I see police records and medical reports that I put on here. I mean, for example, a U visa, which is something we do here in the States for somebody that might be a victim of a crime. Well, obviously, that's very pertinent to your relief, right? Things like IDs, birth certificates, those are going to be something that pretty much every case requires, right? As far as identifying things, but to me, there's a distinction between the things that I can help the client get and the things that I can't. So sometimes it is, I can go get those police records. I can make them certified. I can make them in a format admissible to the court. That's not on the client. But if you've got your birth certificate from Honduras, it's going to be easier for you to provide that to me I can help you as far as if we need to make it a translation, there's services for that. We can make it into an acceptable format for the court. But yeah, that's really the distinction, right? Is things that I cannot go and get sometimes. It's on you, it's on the client to provide that to me.
Matching evidence to the testimony. Obviously, whenever you're going to show a photo or a video or a document, it's going to need to be explained by your witness. They need to understand how to help you get that into evidence.
What we talked about at the very, very beginning of chronological storytelling, right? So if we are, say you made an Excel spreadsheet that was just here's all the sequence of events for my client. You might have a second column there that says, here's where we're throwing in exhibit A, here's where we're throwing in exhibit B. And that way they know kind of how the trial goes. Now, at the end of the day, trials are unpredictable, right? I can have it scripted as best that I can, and things get thrown in, but that's what a good attorney can do, is kind of roll with those punches, right? How do I tell that story even if I can't get that piece of evidence in? Well, that's not something for the client to worry about. That's something for me to worry about, right? So I think of my backup plans in advance.
And sometimes the circumstances that bring people into the need to immigrate isn't necessarily an orderly, calm process, right? Depending on the circumstances. And many times they might not be able to grab the documents or the proof that you wish that they were able to present in your office that you could use in court.
Yes, and this is true in all courts, everywhere I've practiced, even outside of immigration context. I'm trying to think of, well, what would the best evidence be? Okay, if I don't have that, I should at least point out to the court maybe why I don't, or why it's not possible, or don't just leave it lingering and then wondering, well, I wonder why they didn't show that, or why they couldn't show that. Let's go ahead and put testimony on the record that explains it.
Okay. Authenticating digital or multimedia evidence. Obviously, you need to have the client know how to authenticate the evidence. Any special suggestions on when dealing with witnesses and clients in this area?
Just that they need to understand that there is a legal process and there are legal technicalities with getting things admitted. They don't need to know necessarily how to do it. That's what they hired me to do. But they need to understand, if I'm having to ask them a question of like, did you take this picture on your phone? Have you altered it in any way? Like, I'm not trying to question you. That is literally what I have to do to authenticate it, right? So as long as I walk them through that, so they're not, live in trial, like, why the heck is my attorney asking me that?
No, I didn't take the picture, and yes, I altered it.
Well, that's part of preparation. Make sure they don't say stuff like that.
I literally had something like that happen about 6 months ago, to where one of their answers was the exact opposite, and it was the one predicate that I didn't review with the client. And gosh darn it, I didn't feel too smart at that moment. Reid, as you move closer to your microphone, because you cut out in and out a little bit, let's
Sorry.
talk about disclosing sensitive or stigmatized information.
Yes. So yes, in a lot of ways, for example, we do deal with domestic violence in immigration a good amount. For example, VAWA cases, which is the Violence Against Women Act, and that's part of their relief sometimes, right? And they need to know that is kind of a bolstering of their case when we use it, right? Um, as far as disclosing, I mean, yes, we don't do trial by surprise here in the United States, right? So everything is seen by the other side prior to, if we're going to use it. We don't just walk into court and hold up a piece of paper that nobody's ever seen before and say, aha, right? So they need to know that this is part of their case. It will be out there. It will be touched on, right? It will be discussed by me, and the other side will even poke holes in it. And it is a sensitive matter, and you need to be prepared for that.
We've got about 2 minutes to cover these last three boxes. Can you walk us through them?
Yeah, absolutely. So as far as official records, right? I mean, again, that's on me to go and get those as far as getting them in a format that's acceptable to the court. So if it needs to be a certified copy with a raised seal, and these details as far as misspellings and things like, yes, I need to know those and need to have looked at those before so that I'm not blindsided by the other side asking me about inconsistencies with them. I can put testimony on in advance to kind of get ahead of it, so to speak.
So expert
Um,
reports.
yeah, expert reports. I mean, we used one of these. I did a trial in December where we used an expert. This was a expert in Middle East relations in the country of Libya post Gaddafi, right? And I read their expert report front to back, and I found
That's
out
what
more
that
about
that's what I would call a niche expertise.
absolutely. And I now I know more about Libya than I ever did before, but it really helps to for me and for the client to for example read that expert report, know what it says, because the more knowledgeable we are about that, that's going to help our court testimony too.
In preparing
Um,
for evidence challenges.
well, yes. So as far as the opposing party disputing things, right? I mean, again, this is their job to poke holes. Hey, I don't think that photograph is real, or I think your description of it is exaggerated. They need to know that these are the shortcomings of your case. This is where I think, in my experience, the opposing side is going to attack you the hardest, attack you the most, because this is their way to win, right? This is the weakest link in your chain here that is your case. So I got to prep them for that.
Let's go ahead and finish on the last column, overcoming the burden of proof. We've got about 7 minutes left.
Right. So as far as the legal standard, again, I'm their shepherd in this court system, right? It's on me to know what it is that we're trying to prove, and it's on me to prove it. But again, it's their story, right? And they have to, as long as they know how the system works, right? It's a Q&A format, and I can only do the Q. Hey, I'd love to be able to just answer for you. I'd win all my trials if I could just answer for the client, right? But yeah, I mean, it's one of those things that as long as they know what my roadmap to success is and where I'm trying to check all my boxes, then we work as a team together to do it.
Obviously, you need to show consistency over time. Can you delve into that a bit?
Right. Well, and this is a good lawyer, I think, again, looks into, I look at my client's case like I'm the opposing attorney sometimes. And I'm like, what's this? What's the, because I'm anticipating that they will be grilled on the stand in this. So I have to play quote unquote devil's advocate a lot of times, and show them kind of what you're going to need to explain away during the trial.
Credibility is the key to any witness having any impact at all.
Absolutely, absolutely. And so, yeah, I mean, improving courtroom demeanor in a lot of ways, yes, you take your client as they are. Some people are good storytellers, some people are not. Some people are very compelling, very convincing. Some people are not. But you can teach them kind of what people are looking for, right? And so sometimes that's, you know, if you're talking to the judge, look at him in his eyes, right? Because he's probably looking at you to see if you're telling the truth or not. That's something that human beings do, right? So it's little tips and pointers like that, right? Don't be shuffling around. Don't be looking around like this. There are mannerisms that show honesty.
I would think that in immigration cases, depending on the circumstances, the ability to communicate the consequences to you if their case is not granted is critical.
Absolutely, right. And this is part of what we are trying to demonstrate of why I need this relief. Here's what the prospective punishment would be if this court does not grant it, right? Here's what my life would look like. Here's what my life looked like prior to coming here. This is what was going on. I think it would continue or even be worse if I were to go back, right? And that's on us to convince the court.
Of course, our cases are going to be imperfect, and we're going to have evidence gaps, and there are going to be areas where we think the decider of fact may have doubts. We need to address and explain what evidence we don't have, and certainly address the doubts that the trier of fact may evaluate or hear.
Absolutely. So again, this comes down to picking maybe the best person to tell that part of the story. Um, and really just kind of, all right, you don't have a document that shows this or a photograph that shows this. And honestly, again, I've been practicing law for over 11 years. I feel like a lot of people have that misconception that if I don't have something that is a piece of paper, then it never happened and I have no proof. That's not necessarily the case. Testimony is evidence. Oral testimony is evidence. You are swearing on the record that this is true. Is it as compelling? In some circumstances, no. But we have an opportunity to explain certain things, regardless of whether we have a video of that happening. And the burden of proof is not as high as what some people expect it to be from the outside looking in the legal system.
We've got about 3 minutes left. Can you cover these last four boxes for us?
Yeah, absolutely. So as far as leveraging witness credibility, again, this is somebody that if you are, for example, a third party, right? You don't, in a lot of ways, if you don't have a vested interest, your testimony means more, right? You have almost no incentive to lie. So sometimes getting certain people to come in, whether that's an expert witness or a fact witness that can testify to something, but they're not really getting anything out of it, that can compel a court, right? As far as reinforcing themes, again, this goes back to, well, what are the elements that we're trying to prove? To me, I treat those as the themes, right? We've got to convince this court that elements A, B, and C are all proven, to the burden of proof that they're looking for. So your testimony and your documents, you need to kind of point to the court of what element am I proving with that, right? And to me, that's how I keep a theme, right? Right. If I'm trying to show violence in the home country or something of that nature, right? Well, this is what shows that, Your Honor. And we have to kind of point them out. Here's how I'm proving elements A, B, and C.
Preparing for questions from adjudicators.
Yeah, absolutely. And we touched on this earlier, right? So they are there to poke holes in your case, right? They will play devil's advocate just like I did when we did witness preparation. And so what they need to know is don't lash out, don't get defensive, don't get combative. Just keep that mindset of, look, I'm just here to tell you my story. Almost let the chips fall where they may, right? But I'm here and I'm telling you the truth, and kind of do what you will with that, right?
So, Reid, a question that you're not prepared for. If you could roll back the clock 11 years ago, what immigration knowledge do you have now that you wish you had when you first started practicing immigration law? What is that big epiphany that people are going to go, I didn't know that? What is so different about immigration law 11 years into it than before you had the over decade of experience?
As you might know, politically speaking, a lot of these the laws haven't changed too much, right? They've been talking immigration reform for a long time. I don't know. It's a tough question, right? I can't say that there's a specific piece of information that I wish I knew. Like anything else, we call it the practice of law for a reason. We're just practicing. As a human being, I wish I knew everything I knew right now 11 years ago. Not even specific to the practice of law or the practice of immigration law specifically. But something like witness preparation, client preparation, when you're first starting out as an attorney, you're not good at it, right? This is not something that you've practiced, and you will notice as you go through trials. It's hindsight, right? Hindsight is always 2020, but you're like, I should have maybe told him that that was going to possibly come from the other side, or I should have told him, that when you're answering that question, it's I want you to be pointing to that element, right? So it's witness, client, and preparation is something that I'm much better at, and I will continue to improve at. There is no perfecting it, right? It's an art in a lot of ways, not a science. And so, yeah, I mean, absolutely, this topic in particular is something that I have some trials that would have, I wouldn't say the outcome might have been different, but they would have been quicker or been you know less painful had I done more to truly prep and get the clients ready for what that day of trial really looks like. But when you're
As we
an attorney, when you're an
as we
attorney starting out, you don't know what trial looks like sometimes. So
well, and as we bring this to closure, what's the longest you've had a case last?
so in immigration court, they're very quick because, like I said, they're not a Article 3 court. They're an administrative court. Every trial I've ever had was one day. Because of the way that we do it here in the US, the judge kind of makes a predetermination on the admission of evidence at the very beginning of the
No,
case.
no,
So it's
no,
not
not how
like,
long, not how long the hearing can last. From the time the client said, "I want to become a citizen here," you were talking earlier how these cases can last years, right?
oh yeah, oh yeah. Well, I have some that are still, well, I would say the most recent one I've seen, we had petitioned through the USCIS, and they have a portal actually where you can say what are the standard processing times for this particular form of relief for this particular servicing center, and it'll be 80 months or something like that. I mean, they're honest with you. They'll tell you straight up how long it's going to be. I've had some where they were in removal proceedings for 7 years. So they were told that they made their first appearance in front of this immigration judge regarding deportation, and they were just they get a bond, and they don't have their trial date for years. Like their kids are already grown up. Some of the arguments that we would have made back then we're not making now because the kids aren't even minors anymore. So yeah, it changes. The facts change.
So we've been talking with Reid Keutzer. The law firm is lawyerkennedy.com. His contact information, along with the other attorney that helped him prepare this, is on the help sheet. We've been talking about client and witness preparation in immigration cases, and that concludes this presentation.